Now, legal aid involves the provision of free legal services for the poor and the vulnerable. It extends beyond representation by a lawyer in a court to include legal advice and assistance on both civil and criminal matters. While legal aid is the right of every Ugandan citizen in Uganda, it currently amounts to a patchwork of services provided by state and non-state actors. To discuss this a little bit in detail on Talk of the Nation tonight, I am joined by Law Don Dr. Businje Kabumba. Welcome to Talk of the Nation, Dr. Businje.
Thank you.
And tonight we're talking about legal aid. We talk about legal aid, but there seems to be a legal aid policy vacuum and no national legal aid body to manage legal aid service provision. How exactly does this work?
Well, it's as I think I've described it as it's really a patchwork of services. And I'd just like to say that legal aid is one in what should be a whole framework of social assistance or social security. So in Uganda, we understand social security as being NSSF, but
yes,
it should be much broader than that because it relates to vulnerability and how the state responds to that vulnerability. So legal aid really should be one of a bigger framework of medical aid, for instance, national health insurance schemes, grants to the elderly, grants to single mothers who cannot take care of the children, as it is in South Africa, for instance, Botswana, persons living with HIV. So it sort of has to be centered in a broader sort of framework. Now, but in legal aid is particularly important because especially where people interact with the law. Right now, under Article 28 of the Constitution, you have a right to legal aid as such, where you're faced with a capital offense. So it's not a broad right as such. So it's not that if you're faced with the, say, theft charges, criminal charges relating to theft, trespass, etc., you have a right to legal aid as such. That should be the case, but that's not really the case. So you have a right to state counsel, provided by the state and paid by the state only in limited circumstances. And in all other cases, then really you're on your own. Out
of curiosity, why is it limited to capital offences?
It's a resource question that essentially the state cannot provide legal aid in all situations, all circumstances. So they try to limit your right to particular circumstances. But I think for me it arises out of the fact that we have a foreign legal aid system, a foreign legal system. Because in the past, our grandfathers and our fathers did not require legal aid because precisely they understood the legal system. You never found anyone requiring service to a lawyer because the laws, the rules, the customs were understood, so anyone could represent themselves. But now, with the advent of colonialism, you have a whole framework of laws and legal procedures that are ancient and alien. So we talk about Latin. Most of legal language is Latin or Old English.
Res ipsa locita,
in flagrante delicto. So it is deliberately, in some cases, made to be alien. And so Ugandans and other Africans coming into contact with the law have a feeling of alienation, of confusion, of fear. People who enter courtrooms, the judge is in a robe, it's sort of a wig. That makes absolutely no sense. And I'm glad that in Kenya, there are moves to localize it and make it more friendly, to open the court to the people. And once that happens, then the need for legal aid reduces, becomes less and less, because people can understand the law, they can interact with it without the need to, for assistance in that regard.
Okay, now access to justice for the rural and urban poor as well as vulnerable persons is restricted obviously due to several issues like poverty, access to lawyers is limited, and in the rural areas particularly, there is basic lack of knowledge on the procedures of access to justice and available providers of support services. Tends to be a major complaint. So is it really realistic for us to talk about justice for the poor? Can there really be justice for the poor in this context? In this context,
no. And law really is tied to the whole system of power and how the power is furthered. Those with money then get the sense of the law. They can determine what the law is. I'll just give you one example. One of the drinks that is sort of prohibited by law, drinks such as nguli, which are consumed by poorer people. Now, Johnny Walker, you never find it prohibited because precisely it's consumed by those who are affluent. So the law is, and there have been very many studies in this regard, the law protects the rich and the powerful and then becomes a vicious cycle where the rich get richer using the law and protected by the law. Just one example, many of those on death row are those, not necessarily those who were, or those who survived death row, are not necessarily those who are innocent, but in many cases those who could afford very expensive lawyers and very talented lawyers. So you find that those who are killing, those who get sentenced to death and eventually killed by the state, are more likely than not that happens because they didn't have the money to afford legal services, to get around technicalities, to probe evidence, etc. So there's a real dilemma that the law is discriminatory in effect, if not in text. And there's a real problem, especially when it comes to death, but even property.
Yeah.
Just yesterday I was advising a client of mine, but the other person on the side who was selling her land, unfortunately didn't have a lawyer. So it puts you in a dilemma, because you're a lawyer who has been instructed by a client who is powerful, who has money. Then you see this lady unrepresented. And you're talking about a land agreement of 5 pages. And you're talking about vacant possession. You're talking about questions of indemnities and warranties. And
she has no idea what you're talking about.
That's the thing, Rukh-Shana. So aid, legal aid, justice in this context becomes a little bit problematic. So I think ultimately, of course, moves by the Law Society and others are very good to try to provide legal aid. But ultimately, I think the solution must be made in bringing the law home, bringing the law back home, because it was alienated, it was taken away from the people. It was, and I think the movement system tried to do this with the local council courts, etc. I think there was a direct and deliberate effort to do that, and I think we should return towards a more deliberate effort to do that. And I think the Kenyans really have tried, and I think we should move in that direction. Remove the wigs, for starters. Remove the robes. Remove the alienating language. Remove the Latin. You see, it begins from things as simple as this. Not even just the courts, but even Parliament. You see, for me, it's really paradoxical, and I think very strange that someone in an African shirt in Parliament may be ruled out of order because they're not in parliamentary dress, under the rules of Parliament. Yet, this is essentially an alien concept and context. I think it's about making the law one that people can recognize, relate with, know and understand. Then no one will ask for legal aid because they know the law and they can help themselves.
Let's turn to matters of policy. There is a legal aid bill in cabinet which really seeks to establish a body that can devote itself full-time to the provision of access to justice and legal aid to all indignant persons in Uganda. A bit of a mouthful there. Particularly those in peri-urban and rural areas. What, for the benefit of our viewers, what exactly is proposed in this bill?
Now, the whole aspect in the bill is to try to roll out legal aid, to try to make it, create structures and mechanisms by which lawyers can be required to devote a number of hours to people who are indigent, the criteria of deciding who goes where, who gets what aid, and etc. So it's really aimed at directing state attention to the problem of providing legal aid to persons. But of course, there are challenges in there, because it's not worthy that you don't have requirement for doctors to provide medical aid.
That's
so
true.
It's very possible that requirements to force lawyers to provide legal aid may be challenging in terms of the constitutionality, because how do you force me to provide my time, which is expensive and which has been acquired at great expense, to someone? Now, the morality of it aside. So and has been long in coming, the legal aid policy and the legal aid bill, been long in coming, extremely important, but there must be mechanisms where, in the first place, it's volunteer-based. Those who want to do it can do it, and most lawyers already provide legal aid in a sense that we highly subsidize our services.
Really, Dr. Abusinje?
Yes, yes, you see, because part of it is an economic question that, many times, if you are to charge what must be charged, then people simply will not afford it. So even where I talk about your billing, in many cases there's a sense of legal aid in there. But so I think, again, it must be looked at holistically in terms of, ultimately, you cannot throw enough money at a lawyer to provide legal aid to justice, etc. Because you can't pay them enough. They're not enough lawyers to go around. They are talking about 37 million plus people. So ultimately, a more sustainable and a simpler solution must be in making the rules more accommodative, rules that people can relate to.
You raised something very interesting that brings me to my last question. Your profession, the legal profession, is largely seen from the prism of a commercial cause, where lawyers seek to make money, lots of money, more often than not, and live very fancy lives. How can this be reconciled in the context of legal aid? There is no way you guys are going to give legal aid.
It is important, but I think it must begin at the law schools. And we had this debate at the annual law gathering, the Law Society AGM. Some people are saying law is a business. And I found that a little bit problematic, because there's a sense of survival. You must meet your overheads and something like that. But at the same time, there must be a calling element to it, and Justice Kanyahamba was speaking to this. I think it's a bit of both. A business, but must be necessarily tinged towards the public element of it. Now, it must go back to law schools, because you have law students who see success ultimately in monetary terms. And so as long as we're producing those kinds of lawyers who ask, what car are you driving? Where do you live?
Who seem to be the majority, with all due respect.
But yes, and you see, we must, I think, go back to humanizing the law, and so that people don't fear us. So when you say I'm a lawyer, you don't have that immediate knee-jerk reaction. For instance, the lady I was talking about yesterday, who came initially in my office with fear because she wasn't represented, this morning called called me this very morning and said, she was saying Businje. So in a sense, we must remove the fear. And that can only happen if we essentially see ourselves, yes, we have duties to our clients. Yes, we must survive. But at the same time, we're dealing with people. And I think essentially, ultimately, that must be something that we go towards, sort of humanize. We must humanize the profession. Otherwise, I think short-time gain will kill us. You know, Shakespeare once said, the first thing we do, let's kill all the lawyers. So the animus against lawyers is long-standing and it's historical.
And that's a perfect point to end this discussion. Thank you for joining us on Talk
Always
of the
a
Nation
pleasure.
tonight. That was Law Don Dr. Businje Kabumba joining us on Talk of the Nation to discuss a little bit in detail legal aid in Uganda.